Hello, and thanks for watching the Hall & Wilcox Employment Law Update series. My name is Alison Baker. I'm a partner in the employment team at Hall & Wilcox.
And my name is Iona Goodwin. I'm a senior associate here at the employment team at Hall & Wilcox.
The topic that Iona and I are discussing today is managing ill and injured employees, particularly with regard to employees who've been off work for an extended period of time due to an illness or injury. We're regularly asked to advise on this topic with regard to both work-related injuries and non-work-related injuries. And it is a complicated issue for employers to manage. In my experience, often employers start off trying to be very supportive of an employee in their need to take time off. But it becomes more difficult and uncertain as the absence continues to extend. Perhaps the employee not being there is starting to impact on customer relationships and service levels. It might be that because the employee hasn't been there, other employees have had to step up and take on the employee's duties, and that's becoming too much of a burden for those employees. So an employer starts to think about, could I look at ending the employment relationship?
To add to that, Alison, there have been occasions where we've been contacted by employers who have had an employee who's been absent from work for a long time on workers' compensation, and the employer has complied with their obligations as to keeping the employee's position open for the required period of time, and they've reached the end of that required period of time, and they think they can just go ahead and terminate the employee's employment.
Yes, Iona, while they may be able to terminate their employment under workers' compensation laws, there are a whole range of workplace relations and discrimination legislation that then step in to regulate the process and put forward a number of legal requirements as well as legal remedies. If we put to one side the temporary absence protections under the Fair Work Act, as well as the requirements to meet contractual and statutory obligations with regard to notice and leave entitlements, there are three main claims that employees tend to bring if their employment's terminated because they have an injury or illness and they've been away from the workplace for an extended period of time. They are an unfair dismissal claim, a general protections claim, or a discrimination claim. And I'll discuss each of these briefly. Firstly, with regard to an unfair dismissal claim, this type of claim is brought in the Fair Work Commission, but it's not available to all employees. There are a number of requirements employees must meet before they can pursue an unfair dismissal claim. The first is that they must have been employed for at least 6 months before they can bring their claim, or if they're employed by a small business employer, they must have at least 12 months service. Once they get over that service hurdle, then we look at their terms and conditions of employment. An employee can only bring a claim if they earn less than the high income threshold or if they're employed pursuant to an award or an enterprise agreement. If all of those requirements are met, then they can then pursue their unfair dismissal claim. And then we look at two issues in particular to determine whether or not a dismissal is fair or unfair. The first is whether or not there was a valid reason for termination. In the case that we're discussing today, an employer must show that the employee could no longer perform the inherent requirements of their job, and that's why their employment was terminated. We then look at whether or not there was procedural fairness in implementing the termination. So did the employer adopt a fair and proper process when terminating the employee's employment? If either or both of those issues are not satisfied, or if the Fair Work Commission otherwise feels that the dismissal was harsh, unjust or unreasonable, the Fair Work Commission will find there has been an unfair dismissal. The remedies that the Fair Work Commission can order in the event of an unfair dismissal are firstly reinstatement, so putting the employee back into the position in which they were employed, or if reinstatement's not appropriate, then compensation of up to 6 months' pay. If we contrast unfair dismissal with the general protections jurisdiction, with regard to employees bringing a claim, then any employee can pursue a claim. There's no requirement with regard to how long they've been employed or with regard to how much money they earn or whether they're employed pursuant to an industrial instrument. It's essentially a jurisdiction that's available to everybody. In the case of employees who've been terminated because of an illness or injury, we can expect that they'll pursue a general protections claim arguing that they have had their employment terminated because they exercised a workplace right, such as the right to take personal leave, or if they were dealing with a work-related injury or illness, that they were pursuing a workers' compensation claim. Or they might argue that their employment has been terminated because they have a disability. In this instance, the onus then shifts to the employer to prove that the real reason for the termination of their employment was that they could no longer perform the inherent requirements of the position. If an employer is not successful with their defence and the employee is successful in a general protections claim, then the federal courts can look at a number of different options with regard to remedies. It may be reinstatement, or it could be damages for financial loss and also for pain and suffering. The general protections regime is also a penalty regime, which means employers, if they're found to have breached the general protections provisions, can face penalties. The final type of claim I mentioned before was a discrimination claim. Similarly to a general protections claim, any employee can pursue a discrimination claim regardless of service or seniority. In a discrimination claim, an employee will argue that their employment has been terminated because they have a disability. The employer's defence, again, similarly to a general protections claim and an unfair dismissal claim, will be that the employee could not perform the inherent requirements of their position. The remedies available for a successful discrimination claim include damages for economic loss and for pain and suffering.
Yes, Alison. It's important to note that an employee needs to choose one of those particular claims that you've mentioned. An employee can't pursue all three at the same time. From an employer's perspective, however, the process that they should follow to ensure that they've got a good defence to any of those claims is essentially the same process for each claim. And that is, as you've already mentioned, to ensure that there's proof of a valid reason for the termination and also that they followed a fair process. And in the context of today's discussion, the valid reason is that the employee can't fulfil the inherent requirements of their role. Another aspect for the employer to take into account is whether or not there might be any reasonable accommodations or reasonable adjustments that the employer could make to assist the employee to fulfil the inherent requirements of their role. The cases show that a decision about whether or not the employee can fulfil the inherent requirements of their role should be based on independent medical evidence and not the employer's own view. So a prudent employer should direct an employee to attend a medical examination with a medical practitioner of the employer's choice and at the employer's cost. The purpose of the examination is for the medical practitioner to provide their opinion as to whether the employee can perform the inherent requirements of their role or if there are any reasonable accommodations or adjustments in the workplace that the employer could make to assist the employee. Examples of reasonable adjustments might include allowing the employee to have more frequent breaks during the day or perhaps getting an ergonomic chair for the employee. Once the employees attended the medical examination, the employer should receive the report from the medical practitioner. The report discloses that the employee can't fulfil the inherent requirements of their role or that there are no reasonable adjustments the employer can make to assist the employee fulfil the inherent requirements of their role. The employer can then proceed to the next stage. And the next stage is notifying the employee of the outcome of the report, which is that the employee can't fulfil the inherent requirements of their role and that the employer is thinking of terminating the employee's employment because of that outcome. The employee should be provided with an opportunity to provide a response to the employer's position and to provide any additional information, medical or otherwise, that they think the employer should consider before making their final decision. That process can occur via face-to-face meetings or over the telephone, although we find it happens most frequently via written correspondence between the employer and the employee. In some cases, the process might take a little bit longer than expected because employees don't always respond to the initial correspondence or may take some time to come back with a response to the employer. Unless the employee provides any information to the employer that makes the employer change their mind about the decision to terminate the employment, the termination can then occur, and the employee should be notified in writing of the termination of their employment, and any requirements as to notice of termination and the payment of accrued entitlements should be complied with.
Right, Iona, that does sound like a manageable process, but it's important for employers to be patient as they go through the process, because dealing with an employer who's not at the workplace and also who is suffering from health issues, there will be stops and starts. So it's really important to be thorough but also flexible in how you go about implementing the termination. If you're dealing with these issues, Iona and I would be really pleased to assist you, and our details are on the screen at the moment.
We'd also really love to hear from you if you've got any ideas for any topics you'd like us to discuss in an upcoming Employment Law Update series.
Thanks for watching.